Always exciting. Then we're gonna start. So with the legal perspective, and as I said, my name is Frederik. Ooh, moving slides also works. So as I said, we're gonna introduce you to the three most relevant fields of law for algorithmic recruiting, namely discrimination law, data protection law, and the AI Act, which is almost adopted now. Oops. First, non-discrimination law. We all have a human right to non-discrimination, and these human rights treaties were mostly adopted after the Second World War. I'll give a few examples. In Europe, for instance, the most relevant and influential one is probably the European Convention on Human Rights. But the second and the third here, the two United Nations treaties have a wider coverage, cover almost the whole world, namely the Convention on the Elimination of All Forms of Racial Discrimination and the International Covenant on Civil and Political Rights. And in the EU, we also have a more recent human rights, let's call it a treaty for now, the Charter of Fundamental Rights of the European Union. But in practice, these human rights treaties kind of set the moral guidance, but human rights are typically rather abstract. Judges can make it a bit more precise, but in practice, legal practitioners look more towards what lawyers call lower levels of regulation. For instance, in the European Union, there are several non-discrimination directives adopted by the EU. Today we're going to mostly speak about EU-wide rules, but I should warn you that a directive, unlike a regulation, a directive has to be implemented in the national law of each member state. So from member state to member state, the laws may be a bit different. Anyways, there are four non-discrimination directives that are most relevant. And if you take them together, they ban discrimination on the basis of religion, disability, age, sexual orientation, ethnicity, and gender. So you probably recognize these characteristics, as pretty much everybody agrees that you should not discriminate on the basis of such characteristics. There is, as I said, there is a possibility that certain countries, for instance, in Belgium, under certain circumstances, you are also prohibited to discriminate on the basis of income or financial status. So national countries may offer more protection, but this is the minimum that the European Union requires. If you are not specialized in EU law, or if you're not a lawyer at all, this blog post on the screen gives tips on how to read EU legislation, because EU legal texts are not the most sexy and reader-friendly reading. So this is all that in this first block of the lecture today is all general non-discrimination law. So it wasn't specifically written for AI algorithms or digital society or something. So it are the same non-discrimination rules that are applied to people that are denied entrance to a nightclub, or people who feel discriminated in a traditional recruitment process, etc. An important distinction between two types of discrimination is the one between direct discrimination and indirect discrimination. And direct discrimination is pretty close to what in a normal life, if you ask your I don't know, your brother or somebody on the streets what discrimination is, they will have an idea which is pretty close to direct discrimination. Indirect discrimination is a legal concept that is more complicated, and that also covers situations that many people in daily life that are not lawyers might not immediately recognize as discrimination. But I hope it is a bit clearer after this lecture. You could say you could summarize it as follows: that direct discrimination is discrimination in treatment. For instance, a bouncer saying to a boy, a dark-skinned boy, you don't enter this nightclub. Against that is direct discrimination. Indirect discrimination, you could summarize that as discrimination in effect. So more or less neutral practice happens at first glance, but it has the result that there is discrimination against, for instance, people with a certain skin color or with a certain gender. Later on, I'll give an example to try to make it clearer. Here in between brackets, perhaps there's people from the US of people who sometimes see US literature or movies. Direct discrimination, the European phrase, resembles a bit what in the United States they call disparate treatment, and indirect discrimination resembles a bit what in the US they call disparate impact. You can immediately forget this if you want, but if you happen to read, for instance, scientific papers from the US, you will see the connection. But I also warn you, it resembles, but it's not exactly the same concept. For instance, in the US, no, I won't confuse you with that. We'll focus on EU law. So I warn you, there are many blog posts and newspaper articles and reports from the United States about discrimination and AI. But please keep in mind that the rules in Europe are different. So don't be careful when you draw conclusions from US newspapers and reports, etc. Some things that are allowed in the US are not allowed in Europe, for instance. Okay, back to European law. For both direct and indirect discrimination, it is not relevant at all whether the company discriminates on purpose or by accident. So for instance, if a company hires or buys an AI system, typically it is hiring nowadays or licensing, and the AI system discriminates against women, for instance, even if the company can prove we didn't mean to do this, we are well-meaning, etc. It doesn't matter. It can still be sued and fined for discrimination. So in European non-discrimination law, you only look at the effect, not at the intent. An important warning for companies, and that even is still the case if, let's say, a taxi driver company hires an AI system for selecting new taxi drivers, and even if the AI vendor says we have tested everything, our systems are very fair and non-discriminatory, etc., still that doesn't help the taxi company if it is sued for discrimination by the AI system. Later on, let's say that the taxi company would have to pay a fine, then later on the taxi company can try to sue the AI company to make them pay the fine to them, but it doesn't take away of the responsibility and the liability of, in this example, the taxi company. This is one aspect, for instance, where you see that legal definitions of discrimination differ a bit from what most people, most normal people, most non-lawyers would probably find intuitive. Okay, we do one of these automated quizzes in between. This is exciting. Let's see whether this technology works as well. This is the question. Can you answer already? The question is this correct or not?
Now they are all able to answer.
That is very good. By the way, I have to say that I think it's very impressive that all of you come to a lecture on European law on Saturday morning. My compliments and respect. Well, that goes quick. Shall I continue, Daniela?
You can click on the flag on the left if you want to stop. Okay, in order to show the correct answer. Yeah.
Yeah, so EU non-discrimination law, as I said, is general non-discrimination law that was written and developed since the 1970s, basically. So it was not specifically adopted for algorithmic discrimination. Anyways, we continue. So, direct discrimination. This is, for instance, what used to happen in South Africa. So, open, direct discrimination, in this case on purpose as well. For instance, dark-skinned people are not allowed on this beach or something. Luckily, at least officially stopped now in South Africa. This is direct discrimination and basically always prohibited. Or it still happens, sadly, also in Europe and in the Netherlands, where I am from. For instance, here a case from Belgium in which a company openly said, we will not hire, it was a company offering cleaning services for office, etc. And the company openly said, we will not hire people with a dark skin, with a Moroccan background, because our clients don't want that. This is direct discrimination, completely prohibited. There's pretty much no escape clause, no excuse for the company. I'll add one nuance. In some specifically defined cases in the law, something that looks at direct discrimination at first glance may be permissible, but it's really very narrow exceptions. For instance, imagine that you are a designer of women's dresses. Then you are allowed to only hire women as models for your PR pictures in advertisements or something, but very rare. This sadly also still happens in recruitment. For instance, in the Netherlands, every couple of years, journalists or scholars or regulators do a test, and they call employment agencies or temporary employment agencies, and they say, yeah, they fake, they say, I'm an office, and they want to hire, for instance, cleaners or taxi drivers, but only white people, please. And if then the company says, okay, we're gonna then that would be an example of direct discrimination, completely prohibited, and could, I think everybody muted their mic already.
Look at the chapters, sometimes some questions.
Oh, sorry. Yeah, good.
Don't worry. Don't worry.
I'm trying to. Gabriela, very good question. Could we come back to that question later in this lecture? Because this is a big question where data protection law and non-discrimination law interact, and we have some slides on your question prepared. So very good question. We'll come to that in a bit. Yeah, back to the slides now. And please, everybody, mute their mic if you're not speaking. It would be possible to make an AI system in algorithmic recruitment to make it discriminate directly. And you could also try to hide it. For instance, if you know that in a certain neighborhood, a lot of dark-skinned people live, or a lot of non-heterosexual people live, you could tell your AI system, reject all job applications from that neighborhood. That would be illegal direct discrimination, but in practice, I think it is rare. Most of the time when it goes wrong with algorithmic recruitment, it is not about direct discrimination, it's about indirect discrimination. And we're going to get there now. Indirect discrimination, I warn you, is much more complicated than direct discrimination and may, especially for non-lawyers or lawyers who haven't worked with a non-discrimination law yet, it is less intuitive. It's a bit weirder. It is much farther away from what most people, the person on the street, would think of when you're talking about discrimination. I've tried to, it's a very long definition in the directives and in the national law. So I've tried to cut it up in bullet points. Otherwise, the slide will be full of very small letters. So indirect discrimination is a practice that looks neutral at first glance, but in the end, it has the result that it harms people with a certain ethnicity, or gender, or religion, or handicap, etc. But let's keep it with ethnicity for now. This is also prohibited, but there's a nuanced exception, namely, and now it's getting very legalese, namely, if the apparently neutral practice has a legitimate aim and is a proportionate way of trying to reach that aim, then it is not banned after all. I know this is complicated and vague, but I'll apply it to an example in a bit, and hopefully it becomes a bit clearer. So, as I said, nuanced, but a bit complicated. I'll first give a few examples how that could play a role in practice. Perhaps you've heard about this already once. Amazon tried to automate part of its recruitment process. And there are actually good reasons to do that, because in some companies, like Amazon, for one job, they may get thousands of job applications. And if human recruiters have to go through thousands of letters, then perhaps they look seriously at the first 50, or if they have more time, at the first 100. But if you have 5 or 10 good candidates that you can invite for an interview, then you probably will not look very seriously anymore at the other 900 letters. And that feels a bit unfair towards those 900 people who put in days of work, maybe in updating their CVs and writing a nice letter, etc. So it kind of makes sense, even from a fairness perspective, to partly automate the system. So the system might, for instance, say, if you're looking for a lawyer, okay, we put aside all the letters that have not studied law, and you could perhaps make the system say we only look for minimum grades, minimum study results to make a first selection. There are arguments in favor of automating. But modern AI typically works with machine learning, and then you have to show the AI system first examples of how it should decide. So what Amazon did was it showed the AI system, this is the people that we hired in the past. And then the AI system started reproducing such decisions and hired mostly men. And then the Amazon developers told the AI system, don't look at gender anymore. You're prohibited to look at gender. But still the system kept on choosing mostly men, because AI systems are not that intelligent, but are really good at finding correlations. And it turned out that certain colleges and certain universities, combined with certain courses that people chose, correlated with gender. And those are correlations that us humans probably would not have found, because we're, well, we would get bored if we look at 1,000 CVs, and we can't remember that all that well. But AI is really good at finding correlations, not really at cause and effect, but in correlations. In the end, Amazon, and this is one of the richest companies in the world, with hundreds, thousands, tens of thousands people with PhDs in computer science in-house, but Amazon had to give up. You know, our training data are so biased because our recruitment process was so woman unfriendly in the past that we can't train an AI system to react better. So it's good that Amazon stopped the project. They never used it in the wild, but it does show that if even companies with almost unlimited budget sometimes have to give up and say we can't repair the system, it shows how tricky the problem is. Here, another example, just a scientific paper. They hired, they acted like they were an employer and advertised job ads. And then they did not, the researchers did not say, this job ad should be targeted at women and this job ad should be targeted at men. They just said, dear Google system, please show this ad to people. And they advertise like well-paying, high-regarded jobs like manager and less paying jobs like nurse. And then Google's advertising system chose itself something that the advertiser did not request, to show the manager advertisements mostly to men and the nurse advertisements mostly to women. Unclear why the Google's AI systems did so. But yeah, nevertheless, a worrying and discriminatory effect. So these are examples of discriminatory effect that can happen accidentally. And now we're going to take that complicated legalese definition of indirect discrimination and we apply it to an AI situation. I did not take a recruitment situation because the following example fits better with the definition. So here is an example from the US. Perhaps you've heard about practices on the internet. It is possible that Nina and me, or Daniela and me, we all visit an e-commerce site at the same time, and it is possible that we see different prices for the same product, and that can lead to extra profit for the company. And companies do that as well. This is Princeton Review. It's just a commercial company. It doesn't have anything to do with the university. And it is a company that offers extra lessons to high school kids. So if you're a parent with enough money and you live in the US and you want your kids to go to a posh university like Princeton or Columbia or Harvard, you can buy extra lessons that should help your kids to get higher grades in high school, trying to improve the chances that they get into a posh university. Princeton Review offers such tutoring services, extra lessons. And Princeton Review, already before the pandemic, did so over video call, like we're doing now. So for the cost, it doesn't matter whether the kid and the family are in Alaska or Boston or Hawaii, because the teacher doesn't have to travel anyway, right? And Princeton Review asked people to enter their postal code, and then you saw the price. And Princeton Review charges different prices in different postal code, and that leads to more profit for Princeton Review. But it turned out that neighborhoods where more people of Asian descent live, so with ancestors from China or Korea or Japan, those neighborhoods paid on average higher prices. And it were a big difference sometimes. Sometimes the same number of courses, for instance, same number of courses for extra French lessons could cost from $6,000 to $8,000. So serious differences. Imagine that would have happened in Europe, and we apply the definition of indirect discrimination. The first question is, do we have here a practice that is neutral at first glance? What do you think? So the Princeton Review asked you to fill in your postal code. That counts as neutral, because Princeton Review did not ask, please fill in your skin color and then we'll tell you the price. No, Princeton Review asked, please fill in your postal code. So this counts as neutral. Next question, does it harm a certain ethnic group? Yeah, I see people nodding. Yes, indeed. Quite clear. Namely, people with a certain skin color paid on average higher prices, and we saw that the price difference could be high as well. So, banned in principle. But then we arrive at that nuanced exception. It is not banned after all if the neutral practice, namely, and in this case, the neutral practice is adapting prices to postal codes for extra profit. If that practice has a legitimate aim and the practice is proportionate. I know, typical legalese. I didn't make it up. This is just how the law says it. So let's check. Let's assume that the company just aimed for more profit, and I'm sure it did. I don't think they did so because they hated people with an Asian background. So would that be a legitimate aim? And now we're not discussing what the ideal society would be. We're not discussing utopia. We're discussing what a judge in the European Union would probably say. I think because the EU treaties also say that we have a social market economy, nevertheless a market economy. So I think a judge would probably say, yeah, aiming for extra profit is a legitimate aim. Next question is, differentiating prices for more profit, is that a proportionate measure? So lawyers always say proportionate, normal people say reasonable. Is it a reasonable measure, a proportionate measure, to aim for more profit, even though you could have thought of the risk that it harms people with a certain skin color? Well, every difficult question you ask a lawyer, the lawyer replies, well, it depends. And then you look disappointed, and then you say, what, is that everything you can say? And then you push the lawyer, and the lawyer says, well, it depends on all the circumstances of the case. So I say that too. For instance, I think it makes the type of product, I think, makes a difference. For instance, in the Netherlands, everybody, it's quite boring actually, everybody eats bread all the time, like 2-3 times a day they eat bread in the Netherlands. So imagine that price differentiation would be on bread in the supermarket or other supermarket shopping, then every family would feel it every day. But if the price differentiation is on Rolls Royces, probably less than 10 sold in the Netherlands every year, I don't think a judge would worry too much. And I think the price difference should make a difference too for the analysis. Like, is it a huge price difference or only very small? So you see, it depends on all the circumstances of a case. In the case of, by the way, of extra lessons for high school kids, you could say people have a right to education or something. So that would make it even more worrisome. So you see a very nuanced legal rule. Yeah, very nuanced. The nuance is good, but also makes it a bit hard to apply. And we could probably think of more circumstances. For instance, I think if a company has a monopoly or almost monopoly position, it is more worrisome. But if there are hundreds of other companies that also offer extra lessons and people can compare prices anyways, and it's perhaps less worrisome. So judges can look at all circumstances, which is good, but also makes it complicated. So we see this nuanced and complicated definition of indirect discrimination in traditional non-discrimination law can be applied to AI and algorithmic recruitment. And that's good. Mini quiz in between. Namely, is it possible to justify indirect discrimination? You guys are sharp, even on Saturday morning. Yes, very impressive. You're sharper than me on a normal Saturday morning. And pretty much all of you had it correctly. Indeed, indirect discrimination, a possibility of justification, is built into the definition. So it's a very nuanced, and that proportionality requirement gives us room for kind of balancing test of fair fair interest of the company versus discrimination risks. A kind of balancing test is built into that proportionality requirement. Yeah. Yeah. I warn you again, there are some differences from EU country to EU country, but now you know the basics. And I want to point out a very strong point of EU non-discrimination law, namely that it can be applied to new technologies. Dr. Nina Baranowska and me, we are both law and technology scholars, and this is how you want law to look. You want that law remains relevant, even if society comes up with a new technology. It's bad, or at least not ideal, if you have to adopt new laws all the time, because then the law is always behind. So this is how we want law to be. You have general rules, and if there's a new technology, you just apply it to the new situation. So this is really good about non-discrimination law. It also has a weak point, namely that the victims of digital or algorithmic discrimination, they may not realize that they're the victim. So digital discrimination, it may remain hidden. For instance, let's say that you are a parent who buys extra lessons for your high school kid. How would you know that other people pay a different price? And even if the other parent is a neighbor, or you speak to the parent on a neighborhood barbecue or on a school barbecue, then you hear they pay a different price, but you may think, yeah, but her kids are a bit dumb anyway, so she probably got bulk discount. Or you may think they had mathematics lessons, and that is more expensive than French lessons. And even if you push the conversation and you realize you bought exactly the same package and you paid a different price, then you still don't know that people with a certain skin color in general pay a different price. So this is a problem in non-discrimination law, and sadly also not so easy to solve, because the law often reacts to problems by giving people rights that they can invoke themselves. It's in principle a good way of policy making, but with hidden digital discrimination, it is not ideal. That's a weak point, I have to admit. Then I give the floor to Dr. Nina Baranowska, unless you have an in-between question after this introduction of non-discrimination law. But I would suggest that the most complicated and discussion type questions we postpone until after we did the slides.
I see someone raise a hand.
If possible, I do have a question. Or I think maybe first was before me. I don't know.
Please.
No. Okay.
Thank you. So regarding the case that you brought up before, for in Belgium, that some people were discriminated in the hiring of a company because of their ethnicity, I was thinking, is this also applied to religious symbolism? Like, for example, this is a gray area in Europe and in the European Union, because while it is legally allowed for certain countries to basically have policies that they are not allowed certain religious symbols in public spaces, I was wondering, while this can be applied into public spaces, do companies have the discretionary possibility to apply them into their own ethical, for example, statute, or is it also a form of discrimination? So, like, if a private company decides that it does not allow the religious symbolism to be apparent into for example, for the employees, is it also a form of discrimination, or can it be justified because the public can also do that?
A very good question, and a complicated one too. And it is so complicated that a couple of these cases went all the way to the Court of Justice of the European Union, because national judges were unsure how to answer, and then they have to ask the EU court, like, how should I interpret non-discrimination law? I am not I don't know all the cases by heart, but somewhat recent one. It can be allowed, for instance, if a company has a legitimate aim. And so, if, for instance, if a company has an ethical code itself and can have a good story why for the services that that company offers, it is a reasonable requirement. And this company offered a kind of, how do you call that? Welcoming services, like hosting services at the entrance of office buildings. And I think if a company presents that well and says something like it is important to show a neutral image, then it could be allowed. The court, by the way, got much criticism for that decision. But in a case where I personally, and I don't think the judge could see that either, if it's, for instance, for cleaning services or something where the employees don't have any public function or very little, I do not see how a company could ever legitimize it. But a controversial topic, and I think we expect more case law because the EU court got much criticism because many people, and yeah, me think too, myself too, thought that the court made it too easy for companies to have such internal policies. But the court decision was also nuanced. The court said there were many requirements for a company before they could have such a policy. But still, many people, including me, thought that the court was too lenient towards companies. Again, very good question. And let's give the floor to Nina Baranowska now. Thank you for the question.
Yes, hi, good morning everyone after the break. I hope you get some caffeine shot in between, so we can continue. I got my coffee, so I'm prepared. So I will take over the next part of the class. My name is Nina Baranowska. I'm also a lawyer. I have a PhD in European Union law, and I work together with Frederik at FINDHR project, and we are all based in the Netherlands, and we are the legal team for FINDHR, and we met yesterday with many of you. So I know this group is very diverse, and we have also software developers. We have people from different backgrounds, so I hope I will not sound too lawyery and not too legal, and I will do my best to explain some legal concept in a more accessible way, in a non-legal language, which sometimes it's not very human-friendly language. So before the break, Frederik gave you an overview on the non-discrimination law in the European Union, and he explained two basic concepts, direct and indirect discrimination. And as you now know, this all is relevant for algorithmic hiring, because we don't have any specific non-discrimination rules only for AI. So we have to use the general rules that we have. And with this knowledge, now we are entering a new chapter, and I will try to share my screen. And this is the most exciting moment always in every presentation, whether it works or not, but I hope it will. We tried like so many times and prepared, and I hope you see my, yes, works. Yeah, thank you. After COVID, everyone mastered the online presentation skills, so that's good. So we are entering a new chapter. So if we already know what discrimination is, the next question is, what are the legal rules, how to monitor discrimination? And I'm not going to talk about any technical measures, because this is not my expertise, and I will leave it to my colleagues from computer science side. But I will focus on legal perspective, because we do have some legal requirements and also some constraints in law that we have to take into account when we are trying to detect discrimination in AI systems. The base of these legal requirements is that to monitor and to prevent discrimination, we need to use a lot of data, a lot of personal data and also sensitive data. So first, let's imagine that if we have a company using AI-based ranking system, and this is a good company, this is not the company that Carlos explained yesterday, the bad company, but in our example, let's say that it's a good company that wants to prevent possible discrimination, for example, against people with certain ethnicity. In practice, it means that this company might need to use information about ethnicity of candidates and hired people. And the access to this information might be crucial at two different phases of using AI system. So the first one is when we build a model. And different studies already show that excluding sensitive information from building a model, it's not a good idea and it doesn't work, because even if we exclude this sensitive information, we can still get some inaccurate correlation. For example, postal code, as in the previous example, and the ethnicity. So making fairness through an awareness, and this is computer science term, it's not a good idea and it doesn't really work. The second moment when we might need this information, the sensitive information, is when we want to test or monitor the system. So when the system is already working, it's already running, then we might need this information. So for example, if a hiring company wants to check whether the AI tool discriminates against certain ethnic groups, the company might need to know from which ethnic groups are the candidates, and who get hired and who didn't. So from this angle, the more data, the better, and companies should be happy. They always want to more data. But at the same time, we have to be conscious that more collected data by companies creates more problems and privacy concerns. And especially that now in this field, we are talking about very sensitive data as ethnicity, sexual orientation, religion, disability, so very sensitive information. And this tension is also visible in the legal rules, because on the one hand, we have to ensure that the AI system is non-discriminatory and that our AI tool complies with non-discrimination law explained by Frederik. On the other hand, we have a certain legal rules that limit the use of personal data, and especially when we talk about sensitive data such as ethnicity. The rules that regulate the use of personal data, we will find them in data protection law. And generally speaking, in Europe, protection of personal data is a fundamental right. You can find it in the Charter of Fundamental Rights. This is really like a general, this is like a base, very generally speaking, and as a fundamental right, it should be quite general, and you can see it on the slide. But we also have some specific regulation about data protection, and I think you might heard about that, GDPR, which is General Data Protection Regulation. It was like a very fancy, very still fun phrase that everyone is using. So I think you might heard about GDPR. So I will concentrate more about the GDPR. GDPR came into force in 2018. It was enacted in 2016. So 2 years, there was like a waiting time. So it's still kind of a new law. It's not super fresh, and it wasn't designed for the use of data for AI, but it still applies to all AI systems. And GDPR has very broad application, so it applies to all companies of any size, any sector, public bodies, NGOs, etc., if they process personal data. So hiring companies, because they process personal data, they have to comply with GDPR. And what are personal data, I will explain in a second. But first, let's take a look where GDPR is in force. This is, of course, the EU regulation, which means that it directly applies in all 27 member states. So it's not a directive, it doesn't have to be implemented into the legal system of the member states, but it's the same legal act in all EU countries, of course, officially translated. And if a company is based in the EU or it has an office, then this company has to comply with GDPR. But what is also interesting about GDPR, that the company that is based outside the European Union, but that process personal data of people who are here, this company has also complied with GDPR. So in practice, GDPR has much broader scope of application, and that's why it's also so important act not only in Europe but also worldwide. And now let's move what are personal data based on GDPR. So according to GDPR, personal data is any information that is related to a person, so not to a company, not to the weather forecast and so on. So it has to be information related to a person, and this person is identified. So we distinguish this person from the others, or can be identified. And this is also kind of a broad definition as well, because it means that if we have different pieces of information, but we collect them together and we can identify a particular person, this is personal data. Also, if personal data that has been, for example, pseudonymized, but we can still use them to re-identify a person, there are still personal data that falls within the scope of GDPR. So in the table, you can see some examples of personal data. And if you look at the left side, we have, for example, name, ID number, address, email address, photo, etc. What is also interesting about the GDPR, that information that are related to our tools and devices, such as computers, such as smartphones, for example, IP address, there are also personal data. And why it's that? Of course, the reasoning is that because our devices may leave traces and then can be combined with other information and may be used to create the profiles of us, and we can be identified. And just to make sure that this broad concept of personal data is clear for you, let's take a quiz. I think it works. Yes, I think so. I think you can see. So I think you know what to do already. So choose 3 examples of personal data from the one that you see here. Whoa, you are super fast in Saturday morning. I will just wait a little bit. So what are the 3 examples of personal data? Still, some people are still answering. This book club works really good, I must say. Pretty cool. Okay, so let's see the results. Yes, exactly. So great, you did a great job. So this is the date of birth, gender, IP address. There are personal data. Company's name is not related to their person, the same as industrial equipment, so they are not personal information, and weather condition is just information that is also not related to a person. So if the company wants to use personal data, it has to follow a set of principles from GDPR. Yes, and the principle might sound quite broad and quite general, and in practice, they have to be somehow tailored to the way and purpose the particular company is processing data. So they have to be somehow tailored to also the specific context where data are used. So for example, GDPR will not tell you the exact time for how long you have to keep data. You can keep data, whether it's a half a year or 3 years or 1 year, but GDPR instead will tell you that data should be stored no longer than it's necessary. So data protection principles are quite general, but there are more specific rules in GDPR, but every rule, every other provision in GDPR has to be interpreted through the lenses of these principles. The core, this is the core of data protection. And if we take a closer look at the principles that are the core of data protection law. So we have principle of lawfulness, fairness, and transparency, which means that personal data should be processed lawfully, fairly, and in transparent manner. Then purpose limitation says that the data must be collected for a specified explicit and legitimate purpose. Accuracy principle says that personal data must be accurate and kept up to date. Storage limitation principle that says that personal data shall be kept no longer than it's necessary for the purpose. Data minimization principle, this is really important, especially when we talk about the AI systems that are, of course, data-driven and they use massive amount of data. And data minimization principle says that personal data must be adequate, relevant, and limited to what is necessary in relation with the purpose of processing this data. Then we have integrity and confidentiality principle, which is basically about taking appropriate security over personal data, and accountability principle that the controller, the person who is processing data, is responsible for it and has to comply with the GDPR. In practice, also from my personal experience as a lawyer, it's very important to work closely with lawyers, especially in companies, and the lawyers who are specialized in legal compliance, because they can translate those principles and they can help to operationalize this principle to a specific context, the specific purpose of the company, of the processing data. And of course, all these principles apply to processing personal data, but within personal data, GDPR also distinguishes like a subcategory, like a special personal data that deserves more protection. This special category of data, this is also like a very long legal term. So in other words, we can say sensitive data, are personal data that revealing ethnicity, political opinions, religion, trade union membership, genetic or biometric data, health, sex life, and sexual orientation. And the word revealing here, it's very important because it means that also inferred data can be treated as sensitive data. For example, there was a case by Court of Justice of the European Union, which is the main court for European Union law in Luxembourg. And the court said that the name of the partner can reveal sexual orientation. So the name of the partner is also sensitive data, and it deserves like more protection. And when we go back to our discussion about non-discrimination law, which Frederik described at the first part of the class, we see that there is an overlap, but not full overlap, between sensitive data based on GDPR and protected characteristics in the non-discrimination law. And just to remind you, in employment context at the EU level, we have 6 protected characteristics, which is religion, disability, age, sexual orientation, ethnicity, and gender. Of course, in member states, there can be more protected grounds, but this is what is at least like a minimum protection based on the EU law. And if you look at the graph, the age and the gender are protected characteristics under non-discrimination directives, but they are not sensitive data based on GDPR. On the other hand, race or ethnic origin, religion, disability, and sexual orientation are both protected characteristic under non-discrimination law, and sensitive data based on the GDPR. And what does it mean? What this graph means in practice? What is the implication of this division? It means that companies that they want to detect discrimination, they have to follow stricter rules if they want to process, for example, data on ethnicity or religion, and less stricter rules when processing data on gender and age. And just a short attention quiz to check whether the coffee works now. If you could answer this question, well, then we can move forward. So sexual orientation is, whoa, you are super fast, really. Yeah, I think I can. So data revealing sexual orientation is exactly considered as sensitive data, and companies must follow stricter rules if they want to process this data. And gender, it's not a special category of data. It's just personal data, but it doesn't gender doesn't have a status of sensitive data, of special category of data. So great answers. And as I said, there are stricter rules for processing sensitive data. So now the question is, what are the rules, right? So can we even use this sensitive data at all? So in principle, GDPR prohibits the use of sensitive personal data. That's the main rule, the main principle. However, at the same time, and of course it always happens in law, that we have some exceptions. And here you can see the list of exceptions. And with these exceptions, there is a possibility of using sensitive personal data. So as a rule, it is banned. But then if you find an exception that you can under which you can use this data, then there will be it will be possible. And I think in practice the most important exception would be explicit consent. In other words, freely given consent. So if a person explicitly agrees to process their data, for example, on sexual orientation or ethnicity, then it's okay to process it. It's like lawful, it's legally okay to process this information. So then you might think that hiring companies, if they, and there was a question on the chat before that, before the break, so you might think that hiring companies, if they want to monitor the AI tool, they can directly ask job candidates if they agree to process this personal sensitive information to monitor the tool. But however, it's not that easy in the context of hiring. Of course, in law, nothing can be too easy, and but why it's not that easy? Because first of all, there is a power imbalance, so between job candidate and a potential employer, and in practice, a consent of a job applicant will never be freely given. Because of this power imbalance. So applicants, if they want to have a job, they will tend to agree to more things because they are in a more vulnerable situation. They are more pushed because they really want to get this job, so they will probably agree. So, and that's why it cannot be counted as freely given consent. Also, when you look at this list of this exception, the second problem is that there is no explicit exception for debiasing the system or fighting against discrimination in AI systems and so. And there is no specific exception because, as I said, GDPR is the regulation that came into force in 2018. And it was enacted 2 years earlier in 2016. And by that time, the AI wasn't that hot topic as it is right now. And it means that now with these rules that we have in GDPR, it's very hard for companies to use sensitive information to detect and to prevent discrimination. And also that's why the EU regulators decided to have a new regulation about the AI. GDPR is still in force, so it's still applicable also to AI tools when it comes to the use of personal data. So all principles they have to be implemented. Companies have to comply with GDPR. So GDPR is still there, but the AI Act gives more specific rules also when it comes to the use of personal data to fight against algorithmic discrimination. And now we will move forward to the AI Act, and I will give the floor back to Frederik to continue about the AI Act, and I will stop sharing my screen. Yes, Frederik. I think we can move forward because probably you will give some. Also, you will answer some questions that you will give the more the final legal perspective and final legal landscape that we have right now.
Yes, thank you, Nina. Does everybody see my slides? Woohoo! We're doing very smooth, Nina. I feel very professional. And some great questions about fake data, etc. Some slides mention this. So hopefully after the slides, you understand it a bit better. The AI Act, lots of hype, and now really almost adopted. So I now still, so you see slides, but can I forward them? Yes, almost adopted now. And if it is adopted, then it will apply roughly 2 years later. The AI Act is I'm pretty old, so in my long legal career, it is the most complicated piece of regulation that I've ever seen. Luckily for you, I will only give you a summary. The structure of the AI Act is pretty smart, actually. So it has stricter rules for more risky AI systems. On the top, you see some AI systems are completely banned, such as certain type of manipulative systems that you could imagine with some types of targeted advertising or something. Then other systems at the bottom, they have such minimal or limited risks that there are no or almost no rules today, and most of the rules in the AI Act are about high risk systems, and that is quite a number of rules. I suspect, by the way, that in practice the AI Act will not be as influential as the GDPR or something, because most rules apply to the developers of AI systems, so not on users of AI systems. So the rules are mostly applicable to a handful of large companies in Silicon Valley, to a handful of companies in China. So it's not like the GDPR where every bakery shop and every school has to comply with the GDPR. So I'm trying to comfort you. It is extremely complicated, but there's a good chance that you never have to work with the AI Act. Lucky for you. Algorithmic recruiting is listed as a high risk category of AI. So that means it is in the second part from the top. So loads of rules for AI in recruiting. But again, most of the rules apply to developers of AI systems. So the Googles and the OpenAIs and the Microsofts of this world. Not so much a taxi company that licenses AI recruitment system from OpenAI or Microsoft, etc. here I quote a bit more about how the AI Act defines recruitment. So it says that an AI system counts as high risk if it is used to management employees, workers, or people who are self-employed, for instance, in the gig economy. AI systems are seen as high risks if they are meant to be used for recruitment or selection. And then the AI Act gives some examples too. For instance, in the case of targeted job advertisements, you remember the Google advertising system deciding itself, well, the advertiser didn't want so, that Google's advertising system chose, I'm going to show the manager ad mostly to men and the nurse ad mostly to women. Here we see such a situation is seen as high risk. So all the complicated and rather strict every now and then rules apply to Google's ad system in such a situation. Also, what we have been mostly thinking of perhaps today, the second line from the bottom, AI systems that are used to analyze and filter job applications and AI systems to evaluate candidates. So basically, in summary, AI recruitment, clearly high risk. Then there's also AI systems that can be used when somebody has been employed already. For instance, AI systems that evaluate us for promotion, that give out tasks. That is typically what could happen in the gig economy. Now this Uber driver gets a ride, now this Uber driver gets a ride, or now my teenage son used to do that too. Now he has to bring food for, what was it? Well, you know, Uber Eats and all this gig economy food delivery services, etc. It are computers running those employees, right? Yeah, so all this high risk makes sense. Good choice of the EU to see this as high risk. So what are the rules? There are many, so I only give you a few examples. We can skip this. So out of the many rules for high-risk AI systems, and today we're focused mostly on discrimination-related stuff, is that developers of high-risk AI systems must engage in risk management during development of the system and also during the use, because AI systems tend to develop all the time. Partly because the companies do updates, like our laptops get updates all the time. Partly because AI systems, modern AI systems, are typically machine learning based and start to behave differently if they encounter different data and different CVs, etc. So the developers of the AI systems, again, so those are the Microsofts and the open AIs of this world. Google, Amazon, those type of companies. You may know them mostly as for office software, etc. But Microsoft also offers a lot of AI systems for other companies. Risk management during development and during use. So also during the use of an AI system for selecting job applications, for instance. Let's see whether your coffee still works. So, does the AI Act ban any type of AI-driven hiring? You are still impressively sharp on a Saturday. Indeed. Yeah, the AI Act does not ban it, but says it's high risk. You are correct, and I think it is also the correct choice of the EU lawmaker to see it like that. Compliments about how fresh you guys still are. Regarding AI and discrimination, one important thing that the AI Act requires is good data management, because modern AI systems, as I said, usually machine learning, they all run on data and interpreting data. So for instance, you remember the Amazon case where the AI system basically only selected men because the training data, the examples of old recruitment decisions were so discriminatory, so gender biased, and the Amazon AI system started to reproduce that. That's an example of an AI system behaving badly because of bad training data. Now, the AI Act says such training data should be appropriate for the use. And obviously, in this case, like Amazon did, by the way, because they never used it in the wild, the AI developer must think through whether the training data are sufficient to ensure non-discriminatory decision. Sometimes you can repair training data, and sometimes, like in the Amazon case, you should just give up. A similar example in the Netherlands, it is sad, but report after report after report says that the Dutch police engages in ethnic profiling, often subconsciously. I think there's not that much overt, open racism in the police, a bit, but a lot of unconscious ethnic profiling. So imagine that you would want to automate policing in a bit, and a lot of policymakers have high hopes for predictive policing, basically AI-driven help for policing. We have to admit, I would say, don't try it in the Netherlands because there's not good training data. You cannot show the AI system who should you stop on the street as a suspect, because we only have biased training data. So sometimes the conclusion must be don't automate something because we don't have unbiased data. Sometimes you can repair training data. So the AI Act requires that. For instance, pay attention during data collection, pay attention during preparing and labeling and cleaning the data. Really think through, are the data that I have suitable? For instance, training data from France may not help in the Netherlands, and especially since many of the companies developing AI are based in Silicon Valley, and discrimination problems are completely different there than in Europe, for instance. For instance, in the Netherlands, victims of ethnicity and racial discrimination are often people with a Moroccan and Turkish background. While in the US there's much discrimination against people with an Afro-American background. So even if you repair a data set in a way that is good reparation in Silicon Valley, that doesn't mean that the data set is suitable for Europe, for instance. So the AI Act requires AI developers to look at all those aspects. And the AI Act says explicitly, check the data also for possible biases that are likely to lead to fundamental rights problems, or that are likely to lead to discrimination. So the AI Act requires a lot from AI developers, but I think it are completely reasonable and important requirements as well. And of course, don't only examine the data, but also detect, prevent, and mitigate those biases. And again, I add, sometimes, like in the Amazon case, the conclusion must be, we cannot mitigate or repair the system. There are some things that at the moment we just cannot automate in a fair way. Sometimes that has to be the conclusion. Also, check whether there are data gaps. Sometimes there are not enough data of certain minorities. For instance, if you have a minority of, let's say, 3% of the people in the Netherlands have a Polish background, that means by definition, if you collect data about the whole everybody in the Netherlands, that only 3% of the people is about. Only 3% of the data is about people with a Polish background. So depending on how large your sample is, the AI system may work bad on such a minority, or let's phrase it differently, AI systems will always predict better for the majority, because there's more data about the majority, by definition, because that is how you define a majority. So many wise requirements, yeah, in the AI Act. Also, training and testing data should be sufficiently representative, reasonably free of errors, not completely free of errors. That would be unattainable. And again, depending on the purpose. The more risky the situation, the more you should check whether there are no errors in the data. Of course, the developer must think through when and how will the AI system be used. Yeah, and now I'm going to explain a new exception that Nina also discussed, and that was discussed in the chat as well. So we saw the problem. I summarize again. If you're a well-meaning AI company or a well-meaning company that uses an AI system, you want to check whether your AI system discriminates unfairly. I've spoken to insurance companies in the Netherlands, for instance, and they use AI systems to choose for certain customers, will they get insurance, car insurance or not? And the AI system decides. And I ask them, do you know whether your systems deny all non-white people insurance? And they said, no, we don't know, we hope not, but we don't know, because we are a civilized company and we follow the GDPR, so we do not collect data about ethnicity. And that is true. They should not collect or guess who of their customers has a certain ethnicity or religion or who is gay, etc. Companies should not do so and are not allowed by the GDPR to do so. However, if you want to check, is my AI system in recruitment or in insurance, is my AI system, let's go back to recruitment, is my AI system unreasonably discriminating against gay people, for instance, you would need to know who is gay from the people who applies for a job and who you select. A very hard problem. The AI Act introduces a new exception to the GDPR. So such super sensitive data can be used for repairing discriminations in AI systems, but under very strict conditions. Only for high-risk AI, such as recruitment, and very strict conditions. For instance, I saw some people in the chat discussing it. First, try whether you can build and repair your system with anonymous or synthetic data. Anonymous data, as Nina explained, is data that are not subject to the GDPR anymore, but it is very hard to fully anonymize data. Well, you could throw everything away except gender, but then they're not. Then the data are so abstract that you cannot train an AI system anymore. So it's a very difficult balance. It is actually, if the data are still useful, if they're still about persons, then it's almost impossible to anonymize them. But there's another possibility, theoretical possibility, synthetic data. First, I have to mention that research is still going on in computer science about this, and I've spoken, Nina and I, we have many computer science colleagues. We work in an interdisciplinary research institute, and computer scientists disagree among each other and all say it is still difficult because synthetic data is basically fake data that look like real world data, so that looks like a beautiful solution to train and test AI systems. But the more you make synthetic data look like real data, the more chance there is that you accidentally leak data about real people. So a hard balance, and it is not a silver bullet yet. I don't think it will never become a silver bullet, but research is going on. So we could, let's stay optimistic. Perhaps synthetic data will be part of the solution in the future. It is too early, I understand from many of my computer science colleagues, to say it's too early now to see it as a general good solution, but sometimes part of the solution. If you want to read more about that AI Act new exception, we wrote a blog post about it, which we tried to do in not to legalize language. So to save you of reading the horrendously complicated AI Act text. The rules will probably apply around mid-2026 or autumn 2026. It depends on when the EU will publish the final text, and because the AI Act is so long and the EU only publishes the final text after they have the 25 translations in different EU languages. So let's say, for instance, if it is published on 28 August, then the rules will apply from 28 August, 2 years from now, in 2026. It's also possible that in a complicated system of self and co-regulation supervised by the European Commission, that there will be so-called harmonized standards in which AI specialists and companies come together, and then the European Commission will check, did you follow the AI Act close enough? It's possible that such standards give more detailed requirements to comply with these, for instance, the non-discrimination AI Act rules that I just presented. And that was it. This is already the thank you slides. So I would say, since it's a Saturday, please feel free to go outside. Well, if you live in a country with better weather than in the Netherlands. But Nina and I are also still around for answering questions, but we are definitely not insulted. We are already very impressed that you stayed so long on a Saturday morning. So please feel free to go do less nerdy things if you want. But we stick around for questions. I'm gonna try to stop slide sharing. Yes. To be able to focus on you when you speak, I'm not going to read everything in the chat. So if so I don't know what part of the chat was discussion and what part is question. So if you have a question in the chat that wasn't answered yet, please wave and do it by speak your question out too. Otherwise, we have to try to read and answer in the same time. That won't work. At least I am bad at multitasking. Sharadi, I think your hand is up. Could you ask your question, please?
Yeah. So in the first session, you told us that if there is, even if a company inadvertently discriminates, even without the intention, the company has to pay the fine, even though the model is developed by the vendor.
Yeah.
But according to the EU AI Act, it's the vendor who's responsible.
That is very sharp. Yes. You see that often that multiple laws applies to one situation. In this case, it means that they can both be fined. Yeah, okay. Good point. So the AI vendor could be fined under the AI Act, and the AI using company could be fined by the non-discrimination authority. And the AI Act is much scarier because the AI Act has fines that are calculated like in the GDPR, namely as a percentage of worldwide turnover. And indeed, under the GDPR, Facebook once got a fine of €1 billion. So these are the types of fine that even impress big Chinese and big US tech companies. Non-discrimination law leaves it to the member states how large the fines are. So for tech companies, the AI Act is much scarier. But well spotted, this difference. Until you asked your questions, I didn't give that enough thought yet.
Can I follow up this question?
Yeah.
Because this is also interesting, because non-discrimination law also talks about the final effect of the in a recruitment process. So who is selected at the end? And the AI system can be used only, as you know from the previous lectures, they can be used only in like a part of the recruitment process. So at the end, there might be a person revising the decision of the AI system. So even if the system is discriminatory, then, for example, an HR person can choose candidates in a non-discriminatory way. So at the end of the hiring process, we can have like non-discrimination decision, even if the system was biased. So that's the distinction. And I think you should also remember that the AI systems can be used at different parts of the hiring pipeline, but at the end, it's also the decision by the HR recruiter, the final decision who is hired. So as Frederik said, it can be both liable, or maybe at the end, it will turn out that even if the system didn't work properly and was discriminated, then the hiring company made a good choice.
Very good addition, Nina, fully agree.
Okay, thank you.
I'm afraid that I did not follow I'm not such a professional Teams user. I'm afraid that I jumped a queue. If the order in Teams is correct, then Elisabeth was the first one who raised her digital hand. Elisabeth, do you have a question?
Yes, thanks. I'm having two questions. I recently did a data protection impact assessment for an automated credit decision for a German bank, and unfortunately they discriminated in a handful of ways. And there are two situations that about which I'm still thinking since a lot of time. So the first is what they're doing is they give men a radically worse credit score because they say they have statistics given proof that men pay back their loans or do not pay back their loans more often. Which might be true. I haven't checked the statistics, but from a general perspective, I'm wondering, because on the one hand, this is a very rational approach from the perspective of the company, saying, okay, I'm doing some predictions on whether people will pay back money or not based on their demographic, based on their demographics. On the other hand, you are really treating people unjust based on categories like gender. And I think if we would say that this is the possible way to decide, okay, we have evidence that men often don't pay their credit, their money back, then we could also justify racial profiling. Because, at least in Germany, you will always find a statistic saying that, let's say, people of color are more often visible in criminal statistics. I know these statistics have flaws. You also know for sure, but I think this is one really problematic thing. And my feeling tells me that it should be generally forbidden to predict behavior based on demographics of people, because you might be right on a statistical level, but you will do you will do very bad on the individual case. And maybe let me tell the second thing.
Or should we, or perhaps I first answer this?
And, thanks.
I agree with your intuition, but I also understand the company's viewpoint. On the one hand, it sounds reasonable. On the other hand, unreasonable. I think it is prohibited because I know that it is prohibited in insurance, for instance, even if they have statistics.
In insurance, there's a special ECJ decision.
Yes, exactly. So there is a gender anti-discrimination directive, and that said companies are not allowed to discriminate based on gender in basically commercial services. Insurance is one of those services. And there was a specific exception in the law which said, except for life insurance, then companies can discriminate because women live longer. And that was, and the Court of Justice of the European Union said that exception is invalid. So regardless of your statistics, even if there's some rational arguments to use them, because of arguments like Elisabeth just said, it may work well in the aggregate, but it doesn't show anything about an individual. So I haven't looked in credit, but I think I really think that it is not allowed because that gender anti-discrimination directive.
Thanks.
Yeah, it's direct discrimination, right? So there's no general justification ground, no room for a proportionality test.
Yeah, although this is it's seen differently sometimes in German case law, but other question that goes too deep. Yeah, but the other side that I wanted to shed a light on was when you look at those decisions, usually you're not having one algorithm making one decision, but you're having actually 10, 20 decisions in one, and you have path dependency inside. And that's why I'm also wondering where to say where there's a harm at which point, when you have a disadvantage at like maybe one decision and you get to a worse path, for example. So, for example, what they also did, they did a matching of pre-names with a list of foreign names, particularly Turkish names. And if there would be a match, then they would not do the automated credit decision still, but they would take these persons and bring them into manual review. Which is particularly tricky from a data protection point of view, because from data protection point of view, it's actually an advantage to be manually reviewed. But still, there's so much stigmatization in that. And also, I mean, you can differentiate. In that case, it would have been also, from my point of view, and Nina just said, it depends on what will be the final decision. And I mean, the final decision could be correct. Yeah, like a person views the documents, looks if there's some falsery or something like this. But it could happen also that because of this match with the Turkish name list, you need to go to the bank and show your documents yourself, for example. So it could be that they apply like special measures inside the whole decision process. Are
you sure this is a real case and that you just are not thinking about super complicated exam questions?
No, I'm sure it's a real case. Yeah. I've seen it. I mean, since it was a data protection impact assessment, I did not have to say anti-discrimination law allows it or does not allow it. I just told them you have a really high risk.
Yeah, it's a fascinating case.
Yeah.
And you point out the difficulties very well, but I mostly agree with you that this is insanely complicated. I don't have better answers now. But insanely. Well, I add perhaps one more thing, but this is in the future and a general remark. I think if we look back in 20 years, that we will see that we have that we have detailed rules, for instance, for AI and discrimination in predictive policing and in law enforcement, and AI and discrimination and unfairness in insurance, and AI and discrimination in credit reporting, because I think each sector has such intricate differences and risks sometimes that that we need many sector-specific rules. Just like a century ago, we didn't adopt one regulation for the Industrial Revolution. We have product safety law, employment law, safety law in factories, safety requirements for cars, etc. So I think we will end up with many sector-specific laws and perhaps with more detailed rules for credit reporting too. But super fascinating case you mentioned, and it shows how difficult policymakers and society have it. Yeah.
And lawyers as well.
Yeah, especially. Yes.
Okay, thanks.
Indeed. Maria, I hope the Teams gives a fair order.
Yes, thank you very much for really interesting presentations. I also had two questions. The first one would be, I would ask for references or sources on court cases in the EU, if available, related to algorithmic discrimination, if those were already, happening and solved with sentences. And then, unless you mentioned, and I was in a attention drop moment, in that case, apologies. And then the other question was, is the Digital Services Act sort of impacting on the AI Act application, particularly for downstream products, etc.? Thank you.
Both good questions. First, I'll reply to the most difficult one. The Digital Services Act is basically the EU regulation for online platforms such as Facebook, etc. Long and complicated. I think it will actually, in general for society, turn out that the DSA, this Services Act, will be more important for society than the AI Act. In general, for freedom of expression and advertising, etc. But yeah, they interact a bit. One of the things that the DSA says is for very large online platforms with more than 45 million users, like Facebook, etc., they have to do in-depth risk assessments all the time on their platforms, including risks in the aggregate. So I would say that a risk like we saw in the Google example, Google's ad system decided that well-paying jobs should only be shown to men. That should, I think, be Facebook and Google should think through themselves, like, are these risks there, and should mitigate it. So yes, even the DSA is relevant for the topic that we discuss today. But the AI Act is so new that I don't know yet how it intersects, and it's a more general problem that EU lawyers like Nina and I and Elizabeth, I think, are struggling now, that the EU, it's not stupid, but the EU has adopted so many digital regulations in the past 2 years, and there's more coming, that we all get, well, not a heart attack, but get really scared. And I shave off my hair so you don't see that I have gone gray. But how all these acts interact is extremely difficult. I hope that the EU pauses for 5 years now so that we can think it all through. And then about case law, very little yet. There is case law on not really discrimination, but there's an provision in the GDPR about fully automated decision making, like fully automated credit decision. There's case law about that, but that's not really pure discrimination. I hope in a few weeks that a colleague of Nina and me, Tim de Jonge, and I will publish a preprint paper, so a draft on a Dutch case where a dating app is required by the non-discrimination authority to ensure that their dating recommendations are not discriminatory. But it is very rare, court decisions. And I think that is partly because the problem that I flagged, that victims of AI discrimination typically don't know that they are the victim, so they won't go to court. Yeah. Apart from that, by the way, it's a general problem with non-discrimination law. Like in the Netherlands, it's really tragic, but it still happens. A lot of Moroccan and Turkish or boys with a Moroccan or Turkish background get denied entrance at discotheques and nightclubs. They just go to another club. They don't start suing the nightclub. So it's a general problem with non-discrimination law. That people completely understandably have better things to do than suing companies. And in AI discrimination, it's an even bigger problem, the lack of case law. So very little case law yet. Gabrielle? Oh, sorry, now yeah, first Gabrielle and then Andreas. I don't know how Teams orders your questions. I don't know who was first, but Gabriella is on top now.
Okay. No, super quickly, but I think they are replying in the chat, because every time we try to categorize data and collect data to then measure our processes or AI solution, the definition of the category of the data as well, it's complex because gender,
Yes.
you can argue male, female, prefer not to say, but when it comes to ethnicity, sexual orientation, even disability to a certain extent, it's very complicated to define. Like we were in Europe, we have a massive problem with the traveler community or gypsy discrimination. But, you know, very often in all the category the company use on their website, when people are applying, there's no mention of it.
Yeah.
So it's very counterintuitive, or they use white British versus white Irish. And I'm thinking, are they not all white? That's nationality mixing with ethnicity. So I'm just cannot get my hand around it.
Well spotted, a super difficult problem, both in non-discrimination law and in the GDPR. Yeah, well spotted the problem. Yeah, the EU court tends to blow up the sensitive data categories in the GDPR more and more, which I understand. So I forgot, Nina, did you say that the EU court even said if the state requires people to disclose openly on a website, and this was people who got subsidies, so it was an anti-fraud measure. If you require people to disclose on a public website the name of their partner, said the court, well, that is sensitive data, because if you're a man and your partner is female, thereby by disclosing a typical female name of your partner, you disclose your sexual orientation. So it can be very broad, and yes, well spotted, a difficult problem. I'm glad sometimes that I'm not a judge, because they have difficult decisions to make. Who is next? I think Marco, is it possible?
Oh, thank you. I think I will be fast because there's someone else here to ask a question.
Oh, sorry.
So in my case, I think I have two different questions, one and two for different laws. Also, first one, something about like legal based on the GDPR. If we think about the usage of AI systems in one scenario, like for recruitment, like for profiling and piling the CVs and helping a human recruiter, like to screen the abilities, we see that, for example, consent would be the most adequate legal basis, even if it's not like the perfect scenario. But what I see in practice, in my experience, is that the hardest part now is to draft a notice that I will have algorithmic transparency. And then my question for in terms of the GDPR is, how do you see that if you are using systems with this ability on recruitment, you disclose in a suitable manner, like the algorithmic transparency for the user? And what approach would you give? Like you would just disclose like generic statements in a consent box, and then you would redirect in a second layer for a policy or terms and conditions? Or do you think that the first layer in the notice now should inform the user in a more substantial manner about the algorithm? So this is the first question. The second one is about the upcoming legislation, the Data Act. That will another piece that will give a lot of headaches for the providers of related services and the manufacturers of IoT devices. But as a user, and now considering both the B2B and B2C relationship, if you want to capture data for train an AI system, we have now, based on the Data Act, certain provisions to regulate this data sharing and how you can actually enforce certain rules to avoid, for example, unfair contractual behaviors on cloud computing services, or how you will actually regulate the hindrances that you can put in terms of the data that you will share. Considering that ecosystem that the EU wants to regulate, do you think that the Data Act in a future could start like to help to debias the pool of training data? And in one point, I'm telling now, maybe in 5, 10 years or even more, we could create a scenario where companies would have access to a more cleaner data sets in terms that they could start to train and debias from the genesis, because this is one of the problems. If, for example, I request as a legal counsel an audit from an AI system, I want a bias audit, I see the document, but I'm not sure that this audit covered all the bias that I want. And I'm pretty sure that I will have problems using this this system because the data itself has biases in the collection. So do you think that also that the Data Act will correct this problem or will create more problems limiting the sharing of data, and now we'll have a concentration of powers? Like if I'm in a company that I have ability to negotiate better agreements, I have better access of the big tech company.
Could you keep it a bit short, because I hope to answer the other questions
Sorry,
too.
I was just trying to explain, but that's it. Thank you.
Thank you. Last question. I have to admit that I did not. You probably have looked deeper in the Data Act than I. This is one of those many digital regulations that have come out of the EU, and I didn't pay it enough attention yet. But the thing that you mentioned, yeah, perhaps it's possible that because you can get more data from other companies, that could help to debias. I will have to look into that. And your first question was, could you remind me? Not repeat the whole thing, but could you remind the topic?
What level of algorithmic transparency
yeah.
put in the notices for those systems to collect consent?
This is a topic of like every week, like 5 scientific papers are published again, 3 computer science papers and 2 legal papers. They're all still struggling. So there's this yearly conference called FACT. I put it in the chat. It's a whole subfield of computer science now to make computer science more explainable. They're still struggling, and lawyers are also still struggling. So I agree with the problem you flagged, but I do not have an answer, sadly. And then Andreas, who is politely waiting all the time.
Thank you very much. First, yeah, thank you, Nina and Frederik, for the interesting presentation. I have just 2 comments. First one is about the AI Act. You rightly said that most of the applications for high-risk AI systems are imposed on the developers. But I think we should also mention that there are quite a few important applications also for the employers. It's Article 26. And one of these is, for instance, you have to have human oversight. So if an employer uses like a recruitment tool that is based on AI, you have to make sure, for instance, that the input data are representative, and you have to monitor the tool. And if you realize that it's discriminating against any protected group, you should act. Things like this. The other thing is that if it's used for employees, you have to inform them or their representatives. So I think, it's not even for us, for the users of the companies, we will have to learn about this act and to know how to actually, to comply with it, because as you mentioned, the fines are quite high. Second one, I think it was very interesting to hear, and you mentioned Article 22 of the GDPR. I think it's a very important rule. It became even more important after the recent Schufa case, the decision by the European Court of Justice that actually dealt with the credit score. But as we can see from the reasoning, it's now it goes far beyond credit scoring and banks. It's as you said, it might be interesting for any kind of recommendation where you're using a score. And in Austria, we have like a never-ending story concerning an algorithm that was developed by the Austrian Employment Service, Arbeitsmarkt Service. It is internationally known now under the name AMS algorithm. And what it does is actually, it's not even AI involved. It's a statistical model, I think it's based on. But it does group the job applicants into 3 groups according to their likelihood to get another job. And for reaching this for this classification, it uses data like if you are a single parent, if you have like a disability. This is all being used as a data, and therefore many people rightly say, I think that is discriminatory. And after this Schufa case, the Austrian Supreme Court adopted this reasoning and said, well, yeah, that might be, because the argument was always from the employment service, there is a human in the loop afterwards. It's just a recommendation, but it's not as easy as this, because you have this confirmation bias and so on, automation bias. And in the end, it's all about how much time the person has at the employment service. And also, if you don't agree with the algorithm, you have to justify it. And I think that should not be overlooked, that there is a big pressure to follow the algorithm. Yeah. So I think that the Article 22, for the next 2 years at least, it will become very important for many AI systems. Thanks.
Two very good remarks. First, you're right. I exaggerated a bit with the AI Act. Not only developers, deployers have to look at the AI Act too. And secondly, yes, fascinating case law on the GDPR specific rules on AI decisions. And there's more, the provision is more important in practice than I had expected, if you asked me 10 years ago, because the provision exists since the mid-90s, and it's only the past 4 years that there's suddenly case law coming up. A good point, both. You guys remain sharp on Saturday morning, yeah. And Marco, I think I skipped you from the line, sorry. It's hard to see.
Oh no, sorry, I forgot to unraise my hand.
Okay, that is very welcome, actually. Oh, and now I raise my hand. That's an accident. I don't have questions to Nina. Well, I do have questions, but I can ask her Monday in the office. In that case, shall we start enjoying other weekend activities?
Sorry, I just had one more question, which I put in the chat. Sorry, I didn't raise my hand. But really, it's, and this is sort of more somebody working in a recruitment industry. Do you think that the new sort of ISO standard for AI, well, it's for developers as well as users, do you think it's going to be more helpful in terms of changing behavior or the way in which we develop AI and the way in which we use AI than legislation?
Difficult
because
question.
It's more about, an industry standard as opposed to compliance with law necessarily, even though there will be an interplay.
Yeah, difficult question. And predicting is always hard, especially predicting the future. I tend to like law more than self-regulation, such as ISO standards, because law has democratic backing and law comes with fines, and not following an ISO standard doesn't get you fined. So those are more kind of ethical preference that I have. It is, companies can choose to follow ISO or not. On the other hand, it is completely possible that this ISO standard gets kind of whitewashed, or no, that's not fair to call it like that. But AI Act leaves some room for the European Commission to say this standard will help compliance. So especially if such a decision of the Commission comes, then it will be more influential. And I also admit that this is always painful for lawyers, but I admit that of the many things that influence people's behavior, law is only a small part.
If I can just ask a follow-up question.
Economics, technology,
because the driver for this really is the impact on the individual. And if the individual doesn't have access to justice, something you've already kind of alluded to, so people can't actually enforce, so they ignore it, and they continue to be discriminated against. So it's really about how do you change industry, the way in which industry operates. So anyway, I don't have the answer, but it was just a question I had.
No, let's come back to that in 5 or 10 years. It's fascinating. Fascinating point. A good point. You guys have so much energy. Shaz, more questions? Oh no, we just spoke, Shaz, right?
Yes, yes.
Yeah, Frida, more questions.
Hi, do you hear me? Yeah.
Could you speak up a bit?
Do you hear me?
Yeah, better.
Yeah, all right. So I had a question and I wrote it before, like in the chat. So my question on more on the practical side. So there's a practice, it's kind of not explicitly announced by recruiters, but we all know that it exists, like imposing a certain temporary ban on applicants if they are rejected for certain positions. So kind of like maybe 6 months ban, so ATS automatically discards your application if you apply for some position, but you were recently rejected for that. But actually in practice, it could happen that the person maybe includes more experience in curriculum, or maybe has like in one month, maybe gets additional certifications or projects or something, but there is a ban and that position reopens and that person applies, but the system automatically discards. And you can see it like maybe because, for example, in the first round, that person got through ATS, and you know that that company uses ATS. But on this next round, that a position open for 2-3 times, but ATS never got through the same person with additional adjustments to CV through the first round of selection. So you know that these temporary bans actually like works like in this case. So do you see like a case of discrimination, indirect or hidden discrimination in this case? And how would you like not fight the company, but how would like other companies, like we know many companies use that, so how would you battle like fight this case in general, like, and how would you apply maybe AI Act to this case, let's say, to resolve it?
Interesting and difficult. So for indirect discrimination, you would have to show, because I agree with you, it sounds unfair, or it's possibly unfair, but non-discrimination law is not a general fairness law, and non-discrimination law only becomes relevant if it turns out to correlate with a certain gender or with a certain ethnicity. But let's assume for now that it doesn't. It could completely be the case that this happens to men and females in the same proportion. And I also don't. There's no logical reason to assume that this will happen more to certain ethnicities. So, yeah, non-discrimination law only becomes relevant if it harms, for instance, women or men or people, Protestants or Catholics or Muslims. I don't know whether such a correlation exists. And I have to admit, I don't know by heart what the AI Act would say about this. No, I don't know yet. And also
maybe the like discrimination in like not a case of indirect discrimination, but maybe a bias like towards that applicant, like definitely that has a case of like limiting opportunities for a specific person for getting like that job. It's sort of like, okay, you was rejected before, I am ATS, I will discard you at this point just because you were rejected.
Yeah, I see your point, but
for patients in 1 month, in 2 months.
Yeah, I see your point, but I think it is one of the examples where automation and AI leads to new groups that non-discrimination law has never thought about. And
yes,
yeah,
connect this case to exact legal category. So that's why I'm asking, like, where do you categorize it legally, and how do you can maybe make a case to prevent or make a broader discussion of this kind of practice?
If I may
yeah,
jump
please.
in, so like if you think about non-discrimination law, it was traditionally regulated protected characteristic, like typically discriminated groups, like for example based on ethnicity or religion. So unfair treatment has to be linked to one of these protected characteristic. And in the case that you are explaining now, I don't see this protected ground. I think it's also unfair, but there is no link to any ethnic groups. Maybe there is, like if we look deeper, maybe there will be more links. But for now, I don't see this link to the protected characteristic based on non-discrimination law. And I also think that it's unfair. Maybe in some national laws, maybe there are more regulation or equal opportunities, or because we are talking only about the EU law, but the national laws can have more regulations on that. So depending on the country, you can have more protected grounds. But for now, I don't. Yeah, I need to think about that, but I don't see it right now the legal ground for in a non-discrimination law.
But also there is like a thing that in explanation, sort of recommendations to like AI Act, they kind of explain that, for example, if AI system actually causes problems for a person to get their livelihood, to get like their employment opportunities, because in the broader case, it leads the person to like not get employed and hence have less like a livelihood or or like earning opportunities and everything. And if we think about certain positions that are very niche and a person is limited like to less job opportunities than receptionist or admin or something, and he's like maybe specialization is niche. So there are less opportunities, but when the ATS gets like to ban you, so it means that AI ATS directly causes you like lesser opportunities for money earning, like in the broader case. Yeah, but as you say, really, I can't connect it like to a vulnerable group, like or to something. But in the broader case, it falls in the category of AI causing damage problems for a person.
Yeah, I think we will need to take a look at that as well. We will see. I will think about that, but for now I don't see the connection. Right?
You could with a non-discrimination professor, I put it in the chat now. We wrote a paper on this problem: AI discriminating on the basis of new grounds. We don't solve everything, but we gave it. No, we don't solve everything. It's actually one of my main research topics, but perhaps you find something relevant or interesting in the paper, because you flag an important problem, that AI can discriminate on new grounds that fit not easily in non-discrimination law. I think the raised hands are gone. And to be honest, I also have a lunch appointment.
And we have to close.
Yes.
Yeah. Thank you. Thank you so much for attendance Saturday.
Big applause for your energy on a Saturday. I'm very impressed. And enjoy the rest of the weekend. And please also do